Okay, so nice to be here. Thanks, first of all, to IIPLA for this great opportunity. So I know that this is the very last presentation of today, so I will try not to annoy you too much, not to be boring, but it's just a try. So let's see. So I'll be talking about the internet and how the internet changed the landscape of economy and which kind of impact it had upon IPR's enforcement, but also on IPR's creation and monetization. So I'm going to talk about the internet, but I know that you will be already longing a beer, a great Belgian beer, so I will try to talk about the internet and about beer. So hopefully it will be a good choice given the time of the day. So I think that the internet really needs no presentation, because we are all very, very acquainted with the hell of a life that it created for us, especially for us lawyers or managers of IP-based companies. So we are traceable all the time, at any time of the day, and mobile phones are a nightmare, actually. They are pretty smart, but we are not as smart as they are, I think. And so the digital and the internet age actually has increased the importance and the attractive power of intellectual property, because actually it changes the environment through which a company or an artist may communicate their brand or artistic identity in order to make it recognizable to the public and accessible to the public. So now the number one concern is how your product or how your work looks and what kind of user experience you can offer. So it's just like, you know, the Belgian beers. You know, it's a different kind of experience for each bottle you pick. Right? I don't know if there is any Belgian expert. So okay. Of course, the internet has made competition harsher and copying and anonymity easier, and removed all territorial barriers between countries, markets, and legislations, of course. There's a new culture of sharing, even though Belgian beer is not meant for sharing. That's what I learned yesterday in a place nearby. And but this happens every day on the internet. There's a new platform to exchange ideas, information, contents, and goods. Social network environments is the perfect evidence of this. And of course, there is a new culture of facilitated infringement. So there's no authority which governs the internet. There's no source control on the flow of content, of information, of goods. So it's all about, you know, the good news and the fake news. That's a hot topic nowadays. The fake news. So we also have the fake beers. This is not for Danish friends. So this is a Faxe beer. It becomes a fake beer, and this is for the Dutch friends. I don't know. There's someone here, but so it's not from Belgium. But anyway, internet has increased the difficulties for the public to understand what is a true product, what is original, and what is not. So IP owners need to be proactive and implement sound anti-piracy and anti-counterfeiting strategies, otherwise they're lost. They lost the value of their IP assets. It is important now to think a little bit more to what Jeff said earlier, and I liked this approach a lot. And now I am lucky because I have the very last presentation, so I can treasure all the things that you have been saying throughout all the day. So actually, Jeff said that he hasn't even talked about IP. He just talked about information assets. So internet helped creating this kind of environment where IP is just actually information, and information can be traded a little bit quicker and with less formalities than what we could imagine before for products and arts and whatever. The big thing is that this reality is changing business models, and we have seen that from the speech that the eminent speaker from Microsoft had before. I think he's gone. I can see him here now. I'm sorry about that, but the big thing is that some people from Microsoft, which is the giant, the IP giant, which everyone in the world has criticized for decades about very aggressive IP enforcement policies and non-inclusive environments, now comes here and says that we are living the fourth industrial revolution, that and the presentation was full of statements with like power to the people, empower your employees, use your customers. Well, probably that was something they did also before. But this is not about Microsoft actually, but it is the proof of the time which have changed, and this of course affects how you enforce IP. And so the internet needs the IP because the internet is the sole and only place where IP is constantly created, shared, elaborated, exchanged, and sold, where it constantly increases in value. And actually, there's also a lot of brand identity reputation strategy to put in place, because nowadays, if something goes on the internet, the company is screwed. And now I want to take a look on the legal terms of what's happening in the EU in terms of legislation and of course implementation of legislation, because unfortunately this scenario is quite fragmented and there's a lot of challenges that we are facing when it comes to deal with the internet and IP. We're not talking about Italian beers because it's not a big strength, so this is one example, but it's not as good as it looks. Maybe we should talk about wine. Maybe we should talk about wine if you like, but still. So Italy is I think it's a good example, but it's not because it is the place where I come from, but because it is the place where really the digital age posed a lot of challenges for the people who brought a lot of value into IP assets. Italy is the typical example of a land of artisan-like excellence and non-digital IP. So all the riches that we had in terms of, I mean, fashion brands, food, shoes, leather bags, leather apparel, okay? So
I think you're really speaking to a very
all the riches that we have actually are something that is high quality goods that are manufactured in like a really small stores. So artisans, according to a broad, multifaceted and diverse heritage of artisan traditions. So most of the top tier fashion brands in the world come from Italy, and they have built empires starting from artisan-like family business, which have become increasingly famous and popular for their design, tailor-made approach, and old-style manufacturing quality. They have become multinational, keeping the business as close as possible to their traditional roots. So few units produced, top quality fabrics, one season, unique designs, very high prices, limited and exclusive retailers. So the more traditional it was made, the more expensive, the more iconic it was. But now there's the internet. So the problem is that when a customers coming from the Asian countries, which are the most richest, the richest customers in the world are there, they come across with a made in Italy good on the internet, how they distinguish if it's a good one or if it's a fake one? Because when you're on the internet, you can actually feel the fabric. You cannot really understand whether that picture is really good. So these are some examples. You know many of them. I think that these ladies here at this table, they know each one. They are the most popular one. So Prada, Gucci, Dolce & Gabbana. You already are well acquainted with these brands, Armani. But I want to focus on the minor ones, which are Cucinelli and Marinella. So these are really the perfect examples of brands which have kept it the more traditional they could. For example, Marinella is a producer of ties, of men's ties, from Naples, and they actually built an empire just from one single store. Actually, they have never had a franchisee until 2015. They only had one store in the whole world, no sales on the internet at all, and they're one of the most successful tie makers in the world. I wear a Marinella tie here, so if you want to check. Anyway, so this is the kind of brands we are talking about. So this is Fatto in Italia, made in Italy. So on the internet, people choose by the look, so you cannot really appreciate the quality. And this is why most luxury Italian fashion brands struggle every day to fight on the internet low-quality counterfeits sold at cheap prices by unidentified private sellers on e-commerce platforms such as eBay or Alibaba. The misappropriation of original content, copyright pictures, videos, layouts for advertising and promotion of fake goods, fake websites mimicking the visual appearance of the brand owner's official websites, and fake news related to business practices, brand policies, etc. Legal tools for protection exist, but it's really a hard fight. Of course, this is true also for other kinds of IP owners, copyright owners, content owners. These challenges are faced by small content owners such as private artists, photographers, video makers, musical artists, and for big content owners such as movie and music majors, broadcasters, sports league. So the main legal challenges are due to the cross-border nature of the scope of the internet, to the fact that the EU has done a lot, but that the initial favor accorded to the ISPS in order to foster the investments in the new market eventually created legal loopholes that leave both brand and content owners and consumers unsatisfied. And to the fact that there are significant differences between the EU and the US legislation, as well as among EU member countries in terms of interpretation and implementation of these rules. And on this point, I would like afterwards to have some question and answer, because I think that this diverse environment can give us really a lot in terms of discussion and hopefully fruitful changes. So it's the age of copy and paste, right? So I deal every day almost with people working in the fashion industry and calling from the companies and just asking me on the phone, "Hey Luca, can I use a pattern? I just found it on Google." I mean, it's true. It's a true story. It happens every day. And because this is the age we live in. So people just goes to Google and search for illustration art, and you can find these kind of things. Very interesting, very nice. Nobody knows what kind of clearance of rights you have done. Here it is Shutterstock. It's an images provider. You can get licenses for that for this. But you know, a lot of fashion companies, especially the smallest ones, have licenses which actually wouldn't serve for the purpose they need these images. They just buy things for digital content, but they cannot incorporate this stuff into the products. So there's a problem of ISP liability, and there was a huge sharing platform controversy all around the world, especially arising from the famous YouTube case. You're all very familiar with that. So YouTube, you know, is these hosting providers. Users just go up, upload videos, and who cares, right? Just millions of viewers all over the world. So the problem here is if you cannot trace the users, you should go pick the ISP, but we have rules that allow providers of non-content based services to just say that they are not liable. This is the legislation we have in the US with the DMCA. This is the legislation we have in the EU with the EC Directive 31/2000. So the general rule is that an internet service provider has no general duty to monitor, to search for infringing material, to filter, to warn the users of what they're looking at. This is the general rule, and actually this rule encourages free speech, exchange of information, exchange of goods also, but unfortunately there's a lot of doubts that are casted daily, on a daily basis, by a lot of EU courts, and also in the US the issue is not this well settled. So the landmark case in the EU about ISP liability is the Saban case. So we're talking about Belgium, so maybe it's something that's pretty well known. So actually it just sticks with the principle stated in the EC directive. So internet providers are not bound to filter information which is stored on its servers by its service users, and they cannot stop the service. I'm going to be quick now because this presentation is going to take a little bit longer than expected, so I try to switch the beers very close. So the thing is, in a lot of EU member countries, the implementation of the EC directive has not been so consistent. Italy, again, is one of the best examples in this. We're not very proud of this as we are with the fashion brands, but still it's happening. So in Italy, there was a distinction that was drawn by the courts between the active hosting providers and the passive hosting providers, which is a distinction which actually the EC directive doesn't make. Also, there's another major point which regards the notice of takedown that content owners have to send to the ISP to request removal or to request activation of preventive measures. So in the US, for example, the DMCA provides for specific notice and takedown procedures and forms. For example, I know from the US practice that if a content owner sees an illegal video uploaded on YouTube, it has to send a cease and desist with an URL-specific indication of where the content is uploaded. So you have to provide the link of the material. The EC directive, unfortunately, doesn't say anything about the formalities of this notice and takedown notice. This is a problem because the faculty of choosing which kind of formality has to be elected was passed on the legislation of the single member countries, which, you know what, implemented this provision in very, very different ways. In Italy, we didn't say anything about that, so we just stayed with the EU legislator. And the thing is that the courts which had to implement this rule started from saying, yes, you need the link. So content owners needed to send cease and desist with the link indication. But lately, unfortunately, they changed their mind and said that actually also just the title of the work could be okay. So there's a huge unpredictability on the side of the internet providers because they don't know what to do. So we have a lot of cases, most of them from TV broadcasters against internet providers. And you will get, I guess, a copy of these slides from IIPLA. You can go through the cases now. I don't want to be too boring. The thing is that we started in 2011 with a very nice decision from the Court of Milan, which said that actually there was no duty for hosting providers to monitor and filter. And actually, it kept going in this direction. But then we had a new decision from the Court of Rome in 2016, which actually came back to this distinction which the EC directly never made between an active hosting provider and the passive hosting providers. And it actually said that this US platform, which is Break Media, it is a platform really similar to YouTube, just a smaller business. Actually, it had to be qualified as an active hosting provider just because it made advertising services based on the content that users uploaded on the platform. And actually, what it said, what the Court of Rome said, is that Break Media had knowledge of the infringing content because the content owner had sent him a sufficiently specific notice of takedown, but there was no indication of the links, and there were just the title of TV programs such as The Big Brother, without even mentioning the number of the series. So you can see it's a huge issue for ISPs and for the market. So no application of liability exemption. And the case was actually brought to the Court of Appeal, and the Court of Appeal just a few months ago have confirmed this judgment. The thing is that what the Court of Appeal said is interesting. It said, because the internet service provider provides for a platform which allows users to search about myriad of content, and because they do targeted advertising based on that content, it means that they can search content, they can search also illegal content, and it means that they can also filter illegal content. And that is the due diligence minimum requested to the ISPA. The thing is, we go back to the beers. So we filter or we do not filter. The problem is that, for example, I know this case personally because we, like our firm, was assisting and is still assisting Break Media. And we are going to the Supreme Court to debate this in a couple of months. The thing is that Break Media, which is a US company, which had come to Europe to provide its business model and to provide its services, had to geo-block its own activity, and so now you cannot anymore access the content from the EU. And this is because this one. So there's also all the linking, communication, making available to the public saga. The thing is that now at the EU level, there's a new, there's a change of perspective that goes a little bit more against service providers on the internet. There was this very recent Pirate Bay case, which is also said that just the provision of a sharing platform is an infringing act of copyright. So we are going towards this direction. The thing goes back to the L'Oreal versus eBay case. This is also good for e-commerce platforms. So if you have the resources as a service providers to filter, then you have to filter. Nobody knows which is the really economically diligent operator to which the ECJ referred in this judgment. Nobody has implemented this notion yet, but still, this is the minimum. This is another recent case about Daimler. Again, the advertiser is not responsible, but the platform provider could be. So there are a lot of, because of all these things going on, there are a lot of non-judicial enforcement tools which IP owners are trying to use to protect their assets. In Italy, what is happening is that content owners are advocating before the non-judicial authorities, independent authorities such as the competition authorities and the consumer protection authorities and the communication authority, trying to get smarter tools other than cease and desist and judicial and arbitration to remove quickly the content, the infringing content. But actually, the thing is, of course, it works better for famous brands and for big money content. It is not so effective for small IP assets. For example, in Italy, the antitrust authority regularly takes down clone internet websites or fake selling websites or requests of brand owners on the assumption that they are deceitful for the consumer public, because the consumer cannot understand whether it is original content or not. And this, of course, is a harm to the market. Actually, just the last month, the authority took down more than 250 infringing websites, mostly selling fake Italian luxury branded goods. You see, we are talking about these kind of things, what we were talking earlier. So this is a fake Gucci websites. It just mimics the appearance of the real Gucci one. And this is Moncler, same thing. You know, I don't know if you can see the internet domain name of this website, nothing to do with Moncler, but if you look up it on Google, you get to Moncler. These again, other examples, Gucci. Then now we also have this one. We have this brand jaking facts happening on social networks all the time. So a 2016 study held that 1 out of brand profiles online that we come across every day while we navigate the internet are fake or hijacked. Recently it happened with Jeep. The Twitter account was hijacked, and also to the Burger King Twitter account was hijacked by someone claiming it was McDonald's. So the brand owners have a lot to do. Mission impossible, almost. So the conclusive remarks are that, so we have come to an end, so you probably can get something more than a picture of a beer in a while. So the internet environment grows more and more challenging because the pace of technology tends to overcome enforcement tools. Challenges grow for both business operators and consumers because of badly crafted legislation at the EU level and unsettled case law in the different member countries, especially with regard to ISPS liability. Uncertainties shown by both legislators and courts are pushing the economic operators to take justice into their hands, and so to force internet users into vexatious service contract clauses and force the ISPS to implement very rigid filtering policies and even to geo-block their activities with respect to countries with a less secure legislation and case law. As a result, to cite Jeff, it all comes down to contract. And legal safeguard diminish both for consumers and for enterprises, and market becomes more and more fragmented and less competitive. And the guarantee of content access and diversity also diminishes, and the net becomes less neutral. Of course, there's a lot of things going on in terms of free speech and fair use guarantees, and this is not a problem which have been solved. The final takeaway is that, is this what we really wanted when we wanted to develop the internet market as a market? And according to the merchant law approach that we usually have, especially at the EU level. So the other takeaway I will cite our colleague from the Netherlands. So for both companies and artists and IP owners at all levels, the mantra should be avoid the smog syndrome. So be flexible and consider trade-offs, because if you just seek for hard and heavy enforcement, you're gonna have a hard life. So who's gonna take the biggest slice when this comes to pizza? We don't know. We don't know, but hopefully something is gonna happen. Especially from these international debates such as today. So again, thank you for listening to me. Thank you for having thought about fresh beer, and I hope it will come soon to you over your table. Thanks a lot. And if you have questions, I'm here.
Well, thank you very much for your presentation, Luca. It was really interesting, and I think we still have a lot of work to do and a lot of challenges to assess on both topics, actually. So, does anyone has a question about this presentation, or is everybody really hungry? I almost did not dare to ask. So I don't see any questions or raising hands, so I think we can conclude now. And the only thing that rests me now is to give you both a really nice present of IIPLA.